morning. Please be seated. We are here at the time set for oral argument in file number 2026-0023, Jeremy Hanson versus Dabbert Custom Homes LLC. Dabbert? Okay, excuse me, Dabbert. And others. Sitting this morning are Justices Jared Tufte, John Jensen, Douglas Barr, Mark Fries, and I am Lisa Fair-McEvers. Arguing this morning for the appellant is Theodore Ramage. Did I say that correctly? Ramage. And appearing Jeremy Hanson, and counsel for the appellee is Alexa Jameson. All right, Mr. Ramage, if you are ready to proceed.
Chief Justice McEvers, Justices of the Court, Counsel, good morning. My name is Theodore Ramage, and I'm here today representing plaintiff and appellant in this matter, Jeremy Hanson, who's here with me today. This appeal arises from a summary judgment dismissing Jeremy Hanson's construction defect claims on a statute of limitation grounds. At the summary judgment stage, the district court held, as a matter of law, that Jeremy's claims accrued in December of 2015 when he sent Dabbert Custom Homes an email asking, among other things, for an insulation check in the northwest corner of his home. Now, before I turn to the legal issues here, I want to briefly address some of the relevant facts in this case. In February of 2015, Jeremy moved into a house that Dabbert Custom Homes built for him. He was a first-time homeowner, and he had no knowledge or background in construction. And within that first year, he did send an email to Dabbert Custom Homes, raising various concerns. But in response, Dabbert, they sent out various subcontractors, and each time they came out, they performed a range of work. Jeremy watched professionals he didn't hire, using equipment he didn't understand, address problems that were not explained to him nor understood by him. And whenever he was asked whether the problems were resolved, he was told it was, or it was going to be. That pattern repeated for years. It repeated past 2016, and it repeated through 2019. It ultimately produced a written agreement in 2020, which was drafted by Dabbert, that outlined further investigation and further repair work. The discovery rule was designed for exactly this type of case. So was equitable estoppel, and so is the principle that a defendant cannot sit on an affirmative defense. Each of these arguments here today provides this court with an independent basis to reverse. So, with that in mind, I'll address three issues in turn. First, why the district court erred in resolving the discovery rule against Jeremy on summary judgment when this court has consistently held that the accrual determination is rarely appropriate for summary judgment. Second, why the district court applied only a portion of the equitable estoppel doctrine requiring affirmative deception without addressing the duty to disclose exception that this court has also recognized. And third, why Dabbert forfeited its statute of limitations defense by sitting on it for 36 months, expanded litigation, all while having the alleged dispositive document in its possession, which the district court ultimately relied on in its order. So I'll begin here with the discovery rule. This is the third issue in our briefing, but I want to lead with it today because I think it's the cleanest path for this court to reverse this matter. It doesn't require this court to create any new law, and it doesn't require this court to decide any type of date for the accrual. It only requires applying the ordinary summary judgment standard to a record that permits competing inferences. Because in its order, the district court held that Jeremy's claims accrued on December 28, 2015, when he sent Dabbert that email asking, among other things, for an insulation check in his home. That was the court's accrual date. And I think it's important that we're very direct about that email because we're not pretending it doesn't exist. Our brief addresses this. Jeremy did raise some concerns that first year he was in his home. He did notice cold conditions, and he did contact the Home Builders Association. But that's not the end of the discovery rule analysis here. The question is not whether Jeremy noticed that part of his house was cold. The question is whether a reasonable person was on notice that he had a potential legal claim at that time. And that distinction is really important because the discovery rule doesn't just ask whether a plaintiff noticed something or observed something. It asks whether the plaintiff knew or with reasonable diligence should have known facts sufficient to place a reasonable person on notice that there was a potential claim. And this court has repeatedly held that that question is generally factual. Specifically in Reimers versus Omdahl, this court has said that summary judgment is rarely appropriate on the issue of when a plaintiff should have discovered a potential claim. And I think there's also a very good reason for that rule. Accrual depends on context. It depends on what the plaintiff saw, what the plaintiff was told, what professionals told them or didn't tell them.
Was there evidence of frost on interior walls?
There was, Your Honor.
Okay. So in a brand new home, would that not be an objective indication that there's clearly something wrong with this new home?
Well, again, Your Honor, this needs to be taken in the context of what happens afterwards and what.
Why? He was either, you've emphasized your client knew nothing about building homes, and yet he, unless he's a very vigilant person, recognized there was a concern, enough to contact the builder and the association, correct?
Correct.
Saw stuff, observed it, felt it. That's not enough notice for a reasonable person, or is he more than reasonable? Because he noticed it, he took action, but he didn't further investigate. But that's on him, right, under the rule?
Your Honor, and I think this goes to this court's explication in Reimers where, it's almost a two-part test, right? There's a question where of when did that notice occur? And the district court relied on the email as that's the date it occurred. It didn't rely on frost. It didn't rely on what was observed because and I think the district court was treading lightly there because those are factual determinations. And so the district court relied on the email, not on what was observed. And I think that's the really important distinction on what this court has reversed in the past as to how a fact finder would determine what was reasonable under the circumstances. And that's precisely where the district court didn't analyze here. It's just selected the earliest fact, that December 2015.
Well, there were obviously facts before that because he observed and felt stuff that caused him to send that email. The district court said, at least by this date, he had notice. It didn't say it couldn't have occurred before that.
That's fair, Your Honor, but whether or not he appreciated that he had a legal obligation to bring a claim, that's, I think, a question for a fact finder. So I think the district court here drew an inference against, and the critical inference against Mr. Hanson when it determined that that email was sufficient for notice.
Is the standard whether he knew he could bring a claim or whether he was on notice he should investigate to determine if he should bring a claim?
And I think this is where Dabbert's investigation and the subcontractors coming to the home also plays into this as well. Because here, again, that email is certainly evidence that Dabbert could use, Justice Barr, and it may support Dabbert's argument to a fact finder, but it's not conclusive as a matter of law. It wasn't a legal accusation. I think it was more so of a homeowner's warranty, right? It listed ordinary warranty items like nail pops, wall cracks, doorknobs, cabinet repairs, and then, of course, the insulation check. But I think the legal question is important that we need to recognize what would a reasonable person in his circumstance here infer from that request. A reasonable fact finder could say, no, this is a first-time homeowner asking his builder to check out why his house is cold as part of a warranty, right? Not simply asking the builder, let me rephrase, I think it's more so he's simply asking the builder to come and investigate and potentially fix. So I don't think the court gets to make that distinction at summary judgment here between those two inferences. And this is even more important too when we look at what happened after 2015. Dabbert didn't tell Jeremy, hey, we deny responsibility, go investigate your rights. No, they sent subcontractors to come investigate and visit the home. And they performed thermal imaging, they pulled back carpet, they added caulking to areas that Jeremy identified, and they did a door blow test.
Could you explain to me what that is? It's referenced and I don't understand what exactly that is.
It's my understanding that they do a door blow test to identify where there's leakage in a home. So they open up doors and then they gauge pressure. And I'm not entirely certain on how that works either, Justice McEvers, but I know it's to gauge where there's a leakage in the home.
So if a cause of action has accrued, can later circumstances cause it to unaccrue? Or how do these later facts fit in with whether or not it had accrued?
Potentially. And that's what I really struggle with this case, because, was there ever a point, and, we could give hypotheticals here, but is there ever a point where that initial complaint was resolved and then something else came up that was unrelated, right, to the installation? And that's a really hard determination, and I think that's the importance of having fact finders make these decisions as to what would be reasonable in these circumstances. Because it came up in Jeremy's deposition here, he relied on Dabbert. He thought that Dabbert was going to fix this problem, and he thought they were fixing it. And the door blow test too is important because he was told it passed, and Jeremy doesn't understand what that test is. Neither do we. So it's difficult what that communication could.
Whether he understands it or whether we do would be a subjective test, and this is what a reasonable person would understand from hearing that, right?
Correct, Your Honor. And yeah, if you hear, objectively, if you hear that your house passed, is the issue resolved? That's kind of the...
In response to Justice Tufte's question, if there was later affirmative deception, that might impact the accrual date. You kind of imply that, but I never see anything specific identifying any facts other than they tried to fix it. But are you alleging affirmative deception, and if so, what was that?
Well, I think there's two instances where that could come up, and we also raised it in our briefing here as to the Muhammad exception. But as to the affirmative deception here, these are professionals, they're experts with thermal imaging guns. Jeremy testified in his deposition that oftentimes it wasn't communicated to him what they were doing or if it was fixed. It was always kind of just the assumption that, hey, this is fixed, or being fixed. And so it was almost a lack of communication here. We don't know if it was identified or not. And again, I don't want to get into a speculative response here, but things were observed and they weren't communicated to Jeremy. And so I think, again, this goes to a fact finder. And this also brings up an interesting point here too, is that I think the objective standard helps Jeremy here. It was pointed out in the appellee brief, almost that it was a negative, but he had zero construction background. The people who had access to the technical information were the builder and the builder's subcontractors here. And those people were telling him things that changes what a reasonable person may think.
So is it a reasonable person with construction experience or a reasonable person without construction experience?
This would be a reasonable person without construction experience in Jeremy's situation here. I don't think the reasonable person standard would be heightened for a new homeowner.
It almost sounds like you're arguing if someone, whether they accept responsibility or not, makes an effort to address the issue, that makes the time for the accrual to continue indefinitely. Because they've come back and they said, well, we'll try. We'll see if we can figure out what the problem is.
Not necessarily indefinitely, Your Honor, because specifically today, we're not asking this court to set that accrual date. I think that's the hard decision a jury or a fact finder would have to determine as to what point we reach that threshold. Okay, and I think the Reimer's opinion goes there, and it's almost a two-part test. And I think the district court almost collapsed Reimer's under that one question. It set that accrual date and it ended there.
Does the deception theory change the accrual date, or does it just toll the running of the statute of limitations? I maybe misunderstood it from the briefs.
Can you rephrase the question?
So if the defendant is taking actions to deceive the potential plaintiff and to encourage them or discourage them from filing a claim within the statute of limitations period, does that really change when the claim accrued, or does that just extend the expiration of the statute of limitations period under our cases?
I think it would potentially extend. It's a hard question. It wouldn't change the accrual date, which again I think is for the fact finder, whether that's 2015 or a later date, but I think it could potentially extend. And that's where the settlement agreement gets into this too. I think that if Dabbert's rule is adopted here, every homeowner who uses the warranty process essentially starts the statute of limitations right there when they ask for a warranty service. So a request to check on things in and a punch list, right, would essentially begin the statute of limitations. So whether the court wants to look at it as affirmative deception, changing the accrual date, or affirmative deception extending the expiration of statute of limitations, I don't think it really matters.
So are you saying you disagree with the idea that if a homeowner thinks they have a valid warranty claim and they submit that shouldn't necessarily trigger the accrual of a civil action for a repair if that warranty claim isn't satisfied?
I think it's a good way to look at it. Notice of a warranty item is different from negligence in home construction here, especially in the case where you have a home with entire exterior walls lacking
If
insulation.
you're just on inquiry notice of a defect, and that's what you raise to the builder is, I've got a defect here, you need to fix it, isn't implicitly, if you don't fix it under the warranty, I will sue and have the court order you to fix it. It sounds to me like the same thing. Where am I missing?
Brings up another interesting point, because then Dabbert sent a following email in 2016 and says, we understand your warranty has expired, but we're going to continue working with you here. And so again, this is another context issue that a fact finder could look at here, kind of the totality
What
of the
was
circumstances.
affirmed to was that deception? We're going to keep trying? We're going beyond our legal responsibility. How's that affirmative deception?
I think it would be disingenuous for me to say that that's affirmative deception. No, but I think this kind of ties into the equitable estoppel argument then too, right? Where there's a reliance here. Jeremy in his deposition said, he always thought throughout this entire process that Dabbert was going to fix it's wrong. And so that there was some reliance. And so that brings up kind of the second path, equitable estoppel, which is issue 1 in our briefing. And again, this gives the court another independent reason to reverse. Even if Dabbert can point to facts suggesting earlier notice, did Dabbert's conduct throughout this entire process give Jeremy reason to believe that litigation wasn't necessary?
Well, let me ask you this. You mentioned a second email, and maybe it's not the same one that I'm looking at, but the August 25th, 2016, is that the email you're referring to when you talked about the second email?
I believe so, Your Honor.
So the final sentence of that email says, "This concludes the warranty issues on your home. It was a pleasure meeting you. Enjoy your home." Is that not pretty conclusive that, at least at that point,
Potentially, but again,
that it was done?
that brings up another great point. That's not the date the district court set. And again, that may be an inference.
Would that date, if the district court had used that email instead, would that be within the statute of limitations?
I don't even think it's necessarily a question this court needs to get to, because these are reasonable inferences.
That wasn't my question.
Sure.
Hypothetically, let's just put it that way. I'm not saying we need to decide, I'm just asking you, would that have brought it within the statute of limitations?
I do not believe so. But again, these are under Reimers, right? These are factual determinations for a fact finder to make. And so by setting that accrual date, I think reasonable minds could differ here. So the district court only really applied half of the rule when it came to equitable estoppel. The brief touched on it. There was some argument in the appellee brief that this was waived. I think this is really incorporated into the equitable estoppel case law and argument, and that if the court does reach a determination of their reasoning on affirmative deception, I think it is fair to look to an exception there. And this matters here in the case because there's a major information imbalance. These are subcontractors, draft busters that were sent by Dabbert. Those professionals used this complex equipment, thermal guns, door blower tests, and they conducted thermal imaging to ultimately pull back carpet, to replace a plate at caulking. And so there's a lot of things happening and information that these subcontractors are gathering. And it's not necessarily communicated to Jeremy here. He's just kind of relying on what they're doing to fix the problem. And that's exactly what the duty to disclose principle, why that matters. He only received the information that those professionals chose to communicate, and that sometimes he received.
I didn't see any case law or anything saying why you think they had a legal duty to disclose anything to him, when that they had some affirmative duty to provide test reports or anything. It was he just kind of made that assumption in the brief, as I recall.
Sure, and I'm not necessarily sure that Mohammed requires that legal duty. I know the appellees said in their brief the fiduciary relationship there, which is a little, it wasn't necessarily analogous here. But I think that silence, the action of not explaining fully to Jeremy, it impacts, and I think they do have a responsibility here to
Was there a legal duty to get an insulation inspection?
absolutely there was. There was absolutely.
When was that discovered? How does that impact your argument?
That's a really good point. There was a discovery that the insulation was not signed off on. And so potentially, yeah, there was a legal duty there for a insulation check to be done. And we don't know from the record or the evidence here if Dabbert knew that I see I'm in my rebuttal time, but I'll finish this here. I don't think we necessarily know from the evidence if Dabbert was aware that an insulation check was not done. So to answer Justice Barr's question there, yeah, there probably was a legal duty as to the insulation check. I will save the rest of my time for rebuttal.
Thank you, Mr. Ramage. Ms. Jamison?
Good morning. May it please the court, Chief Justice, Justices, Counsel. My name is Alexia Jamison and I represent the appellee Dabbert Custom Homes. This appeal originates from a district court holding granting Dabbert's motion for summary judgment and finding that Hanson's claims were time barred. There are three issues on appeal today: whether Hanson failed to meet his burden to invoke equitable estoppel, whether Dabbert waived or forfeited the statute of limitations defense, and whether Hanson's claims accrued no later than December 28, 2015 as a matter of law. In Hanson's complaint, he alleges breaches of warranty, breach of contract, and negligence relating to the construction of his home in 2015. I think it's important to talk about the timeline a little bit. As Mr. Ramage said, Mr. Hanson moved into the home in February of 2015. Within the first 4 months, he emailed or sent a letter or phone call to the Home Builders Association in which he expressed concerns about the construction of his home. On December 28, 2015, he sent an email to Dabbert Custom Homes indicating that he was experiencing these cold conditions and requesting an insulation check. Now, Hanson lives in this home. He is the only person who is feeling these cold conditions. He's living there day in and day out. I don't believe that Dabbert could have been apprised of any other facts other than what the facts came to be when he had draft busters go out there. Now, along with that timeline, after Hanson said that I'm experiencing these cold conditions, I'm requesting an insulation check, that is the first time that the Dabbert had his subcontractor draft busters come out.
Why should that date be the date when the homeowner doesn't know the reasons why it's cold in the room until after the work done by your client or the subcontractors takes place?
Yes, absolutely. So under the discovery rule, a claim accrues when the plaintiff discovers or with reasonable diligence should have discovered facts giving rise to the claim. It's very important that this court has held that you don't need actual knowledge. So,
Well, and I'm sorry to interrupt, but this isn't something you can see. It's something that you feel, and the fact that a room is cold could be based on a number of factors: leaky windows, lack of insulation, not enough vents, the wrong size furnace. There are all kinds of things that could be the problem. So why is raising such a vague problem the starting point? I still don't understand.
yes, Your Honor, I don't believe that that it was actually quite a vague request because he attributed these cold conditions to potentially insufficient insulation, and that is what this case is the issue today, is insufficient insulation. And what Hanson wants to do is to delay accrual until 2022 when he had an inspector come out. And I want to note that the Nordic inspection says that they believe that there's insufficient insulation and that additional inspection would be required. At this point, he's attempting to delay accrual until he became apprised of all the facts, but all the facts are still not there. We still don't know. Dabbert attempted to figure out what was wrong, and that is where the 2020 agreement comes into play. Hanson reached out to Dabbert Custom Homes in 2019. So from the 2016 email where he said, this concludes the warranty issues on your home, there was 3 years of no communication. There's no communication in the undisputed record. Then in 2019, he said, hey, I'm still experiencing some cold conditions. Dabbert is a local home builder, and he cares about his product, and he cares about the customers that are living and raising families in these homes. So in good faith, outside of the warranty period, he went back with draft busters, and they conducted the blower door test. The blower door test results were provided to Hanson and indicated that it had passed. The blower door test attempts to see, it attempts to measure the temperature to see if there is a draft, if there's potential insulation insufficiency. After the test passed, Hanson still said, I'm experiencing these cold conditions. So Dabbert said, okay, as a full and final resolution and settlement of this matter, I will go out and pull the siding off of your wall and we can look at it together. In no way did Dabbert ever try to conceal anything. In fact, he said, let's go and look. Let's see together, we will pull off the siding, and we built this to standards, but if for some reason something's wrong, we will fix that. This was a release, confidentiality, and non-disparagement agreement that Hanson rejected. He chose not to apprise himself of all the facts, but then attempts later in 2022 to get an independent inspection and say that then that's the point of accrual. Now, I think the district court's analysis was very well because they did what they were supposed to do and they looked at the facts, the undisputed record, in the light most favorable to the non-moving party. And with that, there was a lot of different things, but the district court didn't just rely on this email in 2015. There were a lot of things before that. He probably knew within the first few weeks of living in the home that he was experiencing these cold conditions. He probably knew within the first 4 months when he reached out to the Home Builders Association. This first-time home buyer, not knowing what to do, reached out to the Home Builders Association. But he absolutely knew no later than December 28th, 2015. They gave him the most generous accrual date. They gave him every single break in the book. So I think that the district court correctly found, as a matter of law, that accrual was no later than December 28th, 2015. And that also goes a little bit to the Reimers case that was brought up, and while ordinarily a plaintiff's knowledge is a question of fact, it becomes one of law when based on the undisputed record, only one reasonable inference can be drawn from the facts, and that is straight from Narum. This court held that. However, issues of fact may become issues of law if reasonable persons could reach only one conclusion from the facts. And here, there's only one conclusion. The record is undisputed. And no later than December 28th, 2015, Hanson said, I have noticed that something is wrong. And he attributed those conditions to an insulation insufficiency and attributed it to Dabbert Custom Homes. Now, because Hanson isn't able to delay accrual any later, he attempts to assert the doctrine of equitable estoppel. So with the doctrine of equitable estoppel, that may preclude the application of the statute of limitations defense if there's some sort of ongoing or deceptive practices. Hanson bears the burden of proving that Dabbert made statements intending Hanson to rely on them, that Hanson actually and reasonably relied on those statements, and as a result, failed to timely commence this action, and the conduct giving rise to estoppel occurred before the limitations period expired. So, as I briefed, I don't think that he's able to satisfy all of these elements, but I want to point back to that 2020 agreement and compare it to this court's holding in Narum. The court's holding in Narum stated that when the final waiver of the rescission offer was done, the defendant said, this is it, the plaintiffs still had 1 year to file. As of the date of this agreement, when Hanson decided to reject the release confidentiality and non-disparagement agreement, Hanson still had 1 year to file before the statute of limitations period expired. The statute of limitations doesn't say that if you're on notice of something, you need to file right now. It gives you 6 years. Hanson had 6 years to commence this action, and he waited. He sat on his rights. And then in 2020, when Dabbert said, let's figure this out, let's tear open the walls and see what is going on, Hanson said no. He still had a year to file. I believe in the record that in February of 2021, Jeremy emailed Dabbert Custom Homes and a representative sent him this agreement again. At that point, he still had 10 months before the statute of limitations expired. This is directly analogous to Narum, where this court held that the plaintiff may not invoke the doctrine of equitable estoppel against a defendant unless the plaintiff protects himself and exercises due diligence in commencing the appropriate legal proceeding after circumstances giving rise to the estoppel ceased to be operational. I think that this was a pretty clear indicator that Dabbert was done as a final resolution and settlement of this matter. Dabbert was not going to come out there anymore. Hanson also brings up two very distinguishable but very interesting cases, Muhammad and Kruger. Those, I think, are very distinguishable, first and foremost, because both of those included a heightened duty. There was a doctor-patient relationship, and then there was also a duty that this court has held to. There was a heightened duty between an insurance agent and the insured. These cases are very important because there was concealment of a material fact, and that concealment went outside the statute of limitations. In Muhammad, the concealment was that the defendant was deceased, and that was concealed for months after the statute of limitations expired. Knowing that the defendant was deceased, they asked for an indefinite time to answer, and then waited 2 months after the answer to amend, and then at that point, bring up the statute of limitations and say, hey, you served the wrong party. That was concealment outside the statute of limitations that directly prejudiced the plaintiff. In Kruger, similar, it was a doctor-patient relationship, and there it was concealed from the plaintiff's family that a medical device failed during the surgery, and that's what caused their death. They didn't find out until a year after the statute of limitations period had expired through an anonymous letter from a Good Samaritan. This concealment outside the statute of limitations period did not occur here. Dabbert said a year before the statute of limitations period expired, let's go look. He did everything that he felt he could to try and figure this out for this homeowner. He wants him to have a good home and to be happy there. Hanson still lives there, and presumably whatever conditions he was experiencing, we don't know, because no one has been apprised of all of those facts. The blower door test in 2019 was an isolated goodwill effort that's not sufficient to support equitable estoppel. It was a one-time thing for Dabbert to say, hey, let's try and figure this out, and when they couldn't figure it out, the 2020 agreement, the unsigned settlement agreement, was the next step. Further, because they are not able to invoke equitable estoppel, Hanson asserts that Dabbert waived or forfeited the statute of limitations defense. This one is a little interesting because North Dakota law, I don't believe, has ruled any law on forfeiture, only that under Gustafson v. Poitra, a defendant may waive the statute of limitations defense by failing to properly plead the defense in its answer. It is undisputed that Dabbert properly pled this defense in its answer. We moved for summary judgment 30 days after receiving the transcript from the one and only deposition that took place in this lawsuit, and that was our deposition of Mr. Hanson. Furthermore, if this court were to look at the two cases from the other jurisdictions, Murphy and Turner, those facts are distinguishable. In Murphy, there was no dispute as to when the wrongful act occurred, the plaintiff's knowledge, when they were on notice. So there was no need to prolong a lawsuit for discovery to apprise themselves of all the facts. And within Turner, the lawsuit was continued repeatedly at the defendant's request. Here, Hanson stipulated every step of the way. We didn't make any motions for the court to amend anything. Hanson stipulated every step of the way. So I believe that because we pled the defense, they stipulated that, and we brought in third parties to preserve our client's rights, to preserve our client's rights and to ensure that the record was complete and full. I believe that the waiver and forfeiture argument is without merit. So at this time, we respectfully ask this court to affirm the district court's holding granting Dabbert's motion for summary judgment because Hanson's actions are barred by the applicable statute of limitations. If this court has any other questions for me, I'd be happy to answer. Otherwise, I'll yield the rest of my time.
Thank you, Ms. Jamieson, for your argument. Mr. Ramage, you have a little over 9 minutes for your rebuttal.
Chief Justice, Justices, briefly in rebuttal here. Dabbert's arguments depend on treating disputed inferences as undisputed facts. Dabbert is ultimately asking this court to, 1, treat a homeowner's warranty punch list as conclusive legal notice of a construction defect claim, and 2, treat years of repair conduct, testing, and proposed wall opening repair plans as legally irrelevant. None of those conclusions follow from the summary judgment standard. Briefly returning here to equitable estoppel, after the email in 2016, Dabbert is noting that there's a 3 years gap between that and continued activity, but it's irrelevant. Dabbert resumed repair activity in 2019. It sent draft busters to perform the blower door test, and in December 2019, it scheduled additional work to seal the plate, and in August 2020, it drafted the written agreement proposing to open exterior walls, fill insulation. The fact that agreement wasn't agreed to is also legally irrelevant. It's the conduct here that matters. A builder who says that the warranty has concluded in 2016, but then returns years later to investigate, to test, do repairs, and ultimately propose opening walls here, it's a course of conduct that I think it's reasonable a fact finder could determine that Jeremy relied on. Or could determine that this was Dabbert recommitting to address its problem, whether known or unknown. Whether that determination is reasonable, again, is something that the district court should not have drew an inference against Jeremy on at summary judgment. The record also contains compelling evidence as to how Jeremy actually understood Dabbert's conduct to mean. In February of 2021, he emailed Dabbert and asked for another copy of the agreement, which you just heard. He described it as a document under which Dabbert and other contractors would come and inspect and fix the problem at my home. That's important because this isn't litigation testimony created after the fact or something here. That's Jeremy's contemporaneous understanding of what he believed was currently happening. He believed Dabbert was going to come and the inspectors or the subcontractors were going to come and fix the problem. That's the definition of reliance here. Dabbert also argues that there was no reliance because the agreement was unsigned. But this isn't a breach of contract claim suing to enforce that agreement. The agreement matters because it's evidence of Dabbert's course of conduct here and evidence of what Dabbert communicated to Jeremy. Again, that's not a question whether or not Dabbert has an argument here. Dabbert can argue that to a fact finder, that no reliance was reasonable. But Jeremy can also argue that he continued to believe the builder was working forwards to repairs and ultimately fix this issue, because he did take the step of affirmatively re-requesting that agreement. So again, those are competing inferences. I do want to note as well in the briefing that Dabbert pointed to Jeremy's deposition testimony about workplace injury and financial hardship. I think that also misreads the testimony, and the reply brief addressed that directly. But even accepting Dabbert's broader reading here of Jeremy's testimony, I think that financial hardship and reliance are not mutually exclusive here. A homeowner who believes that its builder is going to fix the problem has less reason to incur costs or retaining counsel. So I think that this is a homeowner without resources to litigate would even be more dependent to rely on their builder here to following through. So financial hardship may explain why reliance was especially reasonable to a fact finder. And again, this is a fact question. So I think all three elements of equitable estoppel are at least factually supported. And the key is that it's factually supported. We're not asking this court to hold that estoppel applies as a matter of law. We're just asking the court to hold that reasonable minds could differ. A reasonable fact finder could conclude that Dabbert's conduct led Jeremy to believe litigation was necessary or unnecessary because they were still investigating. They could also conclude that Jeremy relied on the conduct, and they could also conclude that Dabbert, as the professional builder controlling the repair process, had a duty to disclose material information, specifically the fact that this home was not insulated, nor did it have an inspection signed off on what the various investigations reveal. The district court resolved all of these questions against Jeremy, and it did so by treating the physical repair as if it were a settlement negotiation. But I think they drew contested inferences in favor of Dabbert, the moving party, which was the heir. Lastly, I'll briefly touch on forfeiture, which Ms. Jamieson here mentioned. And she's correct that this court has not yet squarely ruled on the question in this context. But I think that this case is also a really good vehicle for this court to do so because the record is exceptionally clean. The district court's limitations rested on the one document, the December 28, 2015 email. Dabbert had that email the date it was sent. It was an email sent by Dabbert, and it was later produced, or sent to Dabbert, excuse me, and it was later produced as Exhibit D to Dabbert's own summary judgment affidavit. This is not a case where a defendant discovered a limitations defense late. This is a case that Dabbert says in its brief, as well as oral argument, that they needed discovery to determine what Hanson knew or should have known of his claims.
Well, weren't they arguing they needed his deposition?
To confirm what the 2015 email was. But this is where this is a unique vehicle for this court, because they didn't go out and depose Jeremy. They had this email since 2015. They expanded, participated in discovery, ultimately brought in 7 subcontractors to this lawsuit, and then years down the road deposed Jeremy. And it said that they just needed to confirm what they already knew. It was essentially the argument here. They had this document. They waited until May of 2025 to depose Jeremy. By then, this case had been pending for nearly 3 years, and most importantly here, this litigation was participated in, but expanded. 7 subcontractors were brought in.
Expanded for them to provide additional defenses, though, correct? If they're trying to say, if there was a problem, it was the subcontractors, why is there a problem with trying to defend themselves by that?
Well, this is where it becomes very prejudicial to a plaintiff here. This increases litigation costs tremendously. And so if something can be investigated, like they knew, they just needed to confirm this alleged dispositive document here, he should have been deposed, and they should have jumped on the statute of limitations.
If you wanted the issue addressed, you could have brought your own motion for summary judgment, put them to the burden of the proof, or they could have then asked for further time to conduct discovery. I mean, you're placing all burdens on them, like they're representing your client and trying to make his litigation as cost efficient as possible. That's not their job.
Justice Barr, I think the problem here is the combination that Dabbert possessed the document and participated in discovery and then delayed to pursuing this deposition until 2025.
They complied with the court order, right? Which either you stipulated with or didn't oppose. They timely filed everything. They were.
There's no dispute as to that.
Okay.
No dispute. And I think that's where this court doesn't need to necessarily develop a broad rule here. It can simply hold that on this record, a defendant who possesses the alleged dispositive evidence from the outset, delayed testing that defense, and affirmatively expanded and participated in litigation by joining 7.
The district court rejected this argument, right?
That's correct.
What is our standard of review? Is it an abuse of discretion? Because you're not arguing it's a legal issue, because you just said it's fact specific. So what is the standard of review you're asking us to adopt, and what rule of law are you asking us to put forth for future cases?
I think this court has addressed waiver and forfeiture, and they're used kind of synonymously in other districts here. But yeah, this argument was presented to the district court, and it's up for this court to determine if this is an area of case law that can be expanded. Because I think the conduct here is certainly an avenue.
You didn't answer. What standard of review do we apply?
Abuse of discretion, I believe, but I'm not entirely certain. So our position here is straightforward. I think this court has 3 great avenues to reverse this case on. Thank you.
Thank you for your arguments this morning, Mr. Ramage and Ms. Jamieson. This case will be taken under advisement, as all cases are, and this court will be adjourned until 1:30 p.m.